Greetings to you, great students in this course on human rights law and government here at HJI. Thank you for submitting your written assignments, including the bios, which I find fascinating. You have rich and quite interesting backgrounds, come from a variety of countries, Africa and Asia and Europe and throughout the world, South America. And anyway, I hope you get a lot out of this class. I'm enjoying teaching it. And whenever I teach a class, I feel I'm learning. So, there's this concept of lifelong learning. I'm a firm believer. I'm more excited about learning later in life than I was when I was younger. Also, what you will find as you get older, that you're building a foundation. So learning becomes increasingly interesting as you develop your own repertoire of knowledge, your own portfolio of knowledge, because it allows you to build and make wider and deeper connections as you encounter new opportunities to learn and process information, turn that into knowledge and into wisdom. So in this first two modules, we focused on documents coming out of the United States of America. Not because I'm trying to say this is the most important country. It was driven by the fact that this is the 250th anniversary, and right now, our class and its schedule overlapped with the 250th birthday. And there's been so much discussion here in America about the history of this country, and particularly as this country emerged as a republic, which is a form of government where there are representatives of the people who sit in a parliament, or in the case of America, in a Congress of other congresspersons or parliamentarians, they are often called, and those representatives sometimes are divided into two houses of the parliament or the Congress. So in the British tradition, you have a kind of a basic House of Commons, which is the larger body, or the body that engages most in deliberating on policies and issues and legislation and the budget and expenditures on a regular basis. And then you have what arguably is a kind of upper house of called the House of Lords. So you have a House of Lords and a House of Commons that kind of cover two aspects of the population, those that are very deeply engaged in policy and politics, and those who are somewhat removed and can kind of survey in a way from a distance. They don't have to run for office and be down in the mud of everyday politics. So they can reflect and to some extent in the British system serve as advisors, and they have influence, but less direct power than the House of Commons, the lower house, as it's called. In the United States, we also have a bicameral two-house system in our government, a House of Representatives, it's called, not a House of Commons. And we have, rather than a House of Lords, a Senate, which is kind of our upper house. And those who are in the upper house have a longer term of office, 6 years. Those in the lower House of Representatives have 2-year terms, so they're continually out winning the support of their constituents to be reelected year after year. So nonetheless, we covered that information from understanding the foundation of the grievances that the colonists had with the British Empire, with King George III. That's enumerated in the Declaration of Independence, and that was a declaration of we are seceding. We are no longer going to be accountable. We are going to be an independent state. So this was a declaration, a very prominent one that affected subsequent history. The United States declaring itself as an independent nation state, not an empire, but a nation state, not a monarchy, a different type of government, a democratic republic with representatives of the people. Yes, it had an executive, but not a hereditary executive. It didn't pass on from one line of succession through right of birthright, like the son or daughter of the king. It gets passed on. That's not part of the system of the republic. And so we've looked through that. We've looked at the U.S. Constitution. You've done some, and its unique features, the separation of powers, the role of the legislature, the role of the executive or president, the role of the Supreme Court, the process for making amendments, the Bill of Rights in the Constitution. And this has been a model for many other nations, both in declaring independence, let's say from a colonial power. And there were many, many nations that had been under the colonial power of usually a European power, such as England, France, Spain, Portugal, Italy or Germany, Belgium. And there was a period, particularly after World War II, when there was a wide range time era of decolonization. And so constitutions were drafted and even declarations of independence. So it's good that also you can, if some of you choose to write about your own country, if you're from the Philippines or Liberia or Albania and other countries, you might want to compare the U.S. Constitution and yours just to see the similarities and the differences. And today we're going to talk about, and it kind of emerges, and the United States in many ways is part of this, the emergence of the international nation-state system. That is, all of us were born into a world where virtually everyone, like 99% of the world population, was born into a nation state, a country. Most often, that country was a member of the United Nations. If you were part of the Soviet Union, maybe your country wasn't, but after the breakup, you might have become, countries. Certainly, the Warsaw Pact, like Poland and Lithuania and Latvia, Romania and Czech Republic, and Slovakia, etc., became members of the United Nations. So we are organized according to nation states. Where did that system originate? And the landmark turning point was what was called the Peace of Westphalia, or you could say the Treaty of Westphalia, that brought about peace among several European nations that had been locked in war. It's called the 30 Years' War that went from 1618 to 1648. And then it was the Peace of Westphalia. Westphalia is a region of Germany, and two cities where treaties were signed among these various powers to end and certain. So let me move now into my PowerPoint because we'll start to get into that. Let's see, but I need to. I almost forgot to share. Okay, bear with slideshow. from the beginning. Okay, Westphalia and the sovereign state. So Westphalia, again, 1648. This is the Peace of Westphalia, when representatives of the countries came together and worked out a peace treaty. And the core part of the peace treaty, just as it remains today with the United Nations, the core issue for member states of the UN now in 2026, as it developed in 1648, was national sovereignty, that each nation around its territory and the people within that territory and its government are sovereign, meaning they have integrity that no other state should invade or violate their rights and their practices, and should not interfere with the affairs of their state. So the international system, much of life, we could say, prior to nation states or prior to even to empires, and that would often resemble a state of anarchy, which is the absence of central political rule. So it might be a world characterized by various tribes or even pirates going around and invading one another, and a kind of regular state of insecurity. And then, but with the gradual evolution of what we could call political thought and law, we emerge into this international system consisting of sovereign nation states. So in an anarchy situation, it does not have a legislator to enact authoritative prescriptions, which would be what a Congress does. It doesn't have a central executive authority with an effective police power. Remember, essential to a nation state or a working government is not just high ideals and goodwill and a constitution to guide it and laws or rule of law. A key and arguably the most important aspect is the ability to enforce laws, and those who violate the codes or the laws or the rules are apprehended and punished. So that's why it talks here about effective police power and a court system with compulsory jurisdiction over state activities. So the concept of the nation state rejects anarchy, and the people agree that the government can have executive power at some level with limitations, like protecting the rights of citizens, but has this executive power that includes police enforcement and military protection of the borders of the nation state to protect the nation. It's what's called national security. Anarchy does not have this authoritative legislature. It does not have a central executive authority with police power, and it does not have a court system. These are the separation of powers, the legislative, executive, and the judicial system. But even in anarchy, there's not a complete absence of rule of law. There are certain codes, but they're not consistent or effective. Now we're going to distinguish between domestic law, the law within a country, and international law, the law that obtains between countries. So domestic law, sometimes called municipal law, or the laws of a state, are contained in its constitution at the highest and broadest level, then specific statutes or laws that can happen at the federal level in the United States, or at the state level, or at the municipal city levels, statutes, regulations, and then domestic law builds up a history of case law. That means the very various decisions that are made, whether at the Supreme Court level or at a circuit court level or state court level, uh, builds a record of judgment, sometimes called precedent, that which has preceded previous rulings that have come to be accepted. Now, distinguish this from international law, the law of nations. This is the body of rules which are binding not among citizens of a state or between the government and the citizens. It's the body of rules which are binding upon states in their relations with one another. So more modernly, you can say the law of international relations, embracing not only nations, but also other international legal persons. This is in the sphere of international law. What's a legal person? An individual or entity that can enter into legal relations and have legal rights and duties. This is often an individual and a citizen, but it could also, in the international sphere, can be a nation state itself. So what is a state, or what we call a nation state? It's a political system of a body of people who are politically organized. So if you're from Cambodia, you are politically organized. You have a constitution, you have a legislature, you have a system of government. And so you are a nation state. You're a member of the United Nations. And what characterizes this entity called a nation state? You have a territory. You have a territory with, generally speaking, recognized borders. Now, there may be disputes over the border between Cambodia and Thailand, for example. But in principle and in general, there's a clear border that is represented in map making. But you can look at the map of a nation. So that's called its territory. And that territory should not be transgressed. You shouldn't enter that territory without a visa or passport, without permission. And certainly you shouldn't enter with hostile intention, like an invasion. So territory is number one for a state and for sovereignty. Number two, there's a population of people that identify themselves as citizens who, according to the laws, citizens can vote if you're a certain age or whatever. And it's a population where, in the case using Cambodia, say, I'm from Cambodia. I am a Cambodian citizen. Thirdly, it has a government. It has a government that is perceived as legitimate, that the people have had a voice in the establishment of the government. And fourthly, that entity, as a sovereign state, has a capacity to enter into relations with what? With other nation states. Cambodia and Thailand could draft a treaty, like a contract or an agreement between them. Cambodia can be part of ASEAN, the Association of Southeast Asian Nations, and become a member. Cambodia can enter into relations with the other member states of the United Nations. So this concept of a state implies being sovereign, a sovereign state. That is, a state that possesses an independent existence, being complete in itself, without being merely part of a large whole to whose government it is subject. So a state is not like a colony, for example, or it's not a subordinate. Like if you look at the state of New York, we are not a sovereign state. We are what's called a state. We use that term. It could be a province, called a province or a region of the United States of America. That's the sovereign entity. It's the United States of America with all its 50 so-called states that is the single member. There's not 50 members of the UN from the United States. There's one. So there are things called non-state actors, and these can include an international organization, like the United Nations is an international organization. Uh, And according to the United Nations Article 104, the organization shall enjoy in the territory of each of its members such legal capacity as may be necessary for the exercise of its functions and the fulfillment of its purposes. So the UN, although not a single state, is a legal entity, and in this sense, a legal person using legal language. Non-governmental organizations are non-state international legal persons, the International Committee on the Red Cross, International Chamber of Commerce, Amnesty International. Individuals are non-state international legal persons, like, let's say, a refugee. Companies like Samsung or Meta, Google, they also are legal entities. Others, insurgents in a civil war, ethnic minorities, etc. It was Gaius in Rome in the 2nd century who distinguished between civil law and law of people in general, civil law being more localized to a particular state or city-state, and jus gentium as applying to all people, kind of more universally. And reading from a quote from Gaius's Institutes, quote, every people that is governed by statutes and customs observes partly its own peculiar law and partly the law common to all mankind. So he's distinguishing their own peculiar, that means their unique laws of the city, but also laws that are common to all mankind, in the sense that there are some universal norms that get applied in laws that all human beings would agree to. That law, which a people establish for itself, is peculiar to it, is called jus civile, as being the special law of that state, the unique laws, while the law that natural reason, which all people theoretically, according to Gaius, share, establishes among all mankind, all people, is followed by all peoples alike, and is called jus gentium, as being the law observed by all mankind. So you can talk in a way about domestic law or the law of a particular country or city-state and universal law. And to some extent, that idea of universal law ties in with the idea of international law. So the steps toward building a community of nations, which started with Westphalia, the steps are the highlights in this process. First was the Peace of Westphalia, as I've discussed, in 1648. This established this model of the sovereign state and an agreement among several sovereign states to abide by a certain set of laws or principles. This got further enhanced in 1850 with the Concert of Vienna, or the Congress of Aix-la-Chapelle in 1818, among England, France, Austria, and Russia, who came together after Napoleonic wars among these countries and agreed to certain principles and respect for national sovereignty of each other, bringing about a peace. The next major step was after World War I, which took place from 1917 to 1919. And that was the effort to create, or the creation of, when they met in Versailles outside of Paris, the Paris settlement, creation of the League of Nations, the forerunner of the United Nations in 1990, where about 40 nations signed on. It turned out, even though the United States initiated this effort, the president then being Woodrow Wilson, who came to Paris 1990 hopes of establishing this league. But interestingly, Woodrow Wilson was the executive, but his legislative body, the Senate, did not approve of the U.S. joining the League of Nations. They were tired, exhausted from World War II, and didn't want to get entangled with other nations. So this weakened the League of Nations. World War II was another second horrific war that took so many lives. And in its wake, there was the establishment of the United Nations. The charter was signed after being drafted in San Francisco in June of 1945. Now, this just checking, I don't know whether my sound went off. I hope not. Many early theologians saw the human race as a single society. Francisco de Vitoria in the 16th century at the School of Salamanca in Spain said international law has not only the force of a pact and agreement among men, but also the force of a law. For the whole world, being in a way one single state, has the power to create laws that are just and fitting for all persons, as are the rules of international law. So this was Francisco de Vitoria. And writing at this time, many of these great thinkers and scholars were coming from Europe, were rooted in the Christian tradition. Alberico Gentile, originally Italian, moved to England, states, all this universe which you see, in which things divine and human are included, is one, and we are members of a great body. And in truth, the world is one body. This public and universal state formed by the world. So this is from his 3 books on the law of war by Alberico Gentile. So this ideal of even moving beyond nation states to becoming a universal society is also there within the mind and aspirations of humanity. Another great giant in this realm is Francisco Suarez, also from the School of Salamanca in Spain, who writes, the human race, howsoever many the various peoples and kingdoms into which it may be divided, always preserves a certain unity, enjoying the natural precept of mutual love and mercy, a precept that applies to all, even to strangers of every nation. Guidance is in large measure provided by natural reason. So we all have this capacity for reason, and we all have the capacity to understand certain basic principles. You can see this in, again, the Declaration of Independence. We hold these truths to be self-evident to any human being. So these are laws to be introduced by the habitual conduct of nations. In his book, Law of Nations. So these are early international law scholars, including Francisco Suarez. So Westphalia is engaging in international law. It is the majestic portal which leads from the old into the new world. The old world was a Christian hierarchy under the Pope, talking about Europe. and the Holy Roman Emperor, these twin poles, the Pope and the Emperor. The new order was a coexistence of a multiplicity of states, each sovereign within its territory, equal to one another, at least theoretically. Some were more powerful than others, but in principle, just like human beings, some of us are stronger than the other, or have this trait or that trait, but we are considered theoretically and aspirationally equal to one another. And these states are free from external earthly authority. That is, their sovereignty means a certain degree of independence. These are quoted from Leo Gross, who you've read for this week's module, scholar who taught at Harvard and Columbia and wrote about Peace of Westphalia, the article that you're assigned to read. So the Peace of Westphalia consecrated the principle of toleration by establishing the equality between Protestant and Catholic states and by providing some safeguards for religious minorities. This was secured by an international guarantee. Westphalia decided to create a context for free trade and abolishing barriers to trade. So in that sense, Westphalia advocated a kind of laissez-faire when it came to commerce and trade. And Westphalia was the starting point for the development of modern international law. It constituted, according to F.H. Hensley, the first faint beginning of an international constitutional law and the first instance of deliberate enactment of common regulations by concerted action. Heretofore, this had not happened in history. But this aspiration did not fully come about, according to Gross. Instead of heralding the era of a genuine international community of nations subordinated to the law of nations, to international law, it led to an era of absolutist states, to a point where the idea of an international community became an almost empty phrase. So it is true that Westphalia's aspirations didn't immediately come into full fruition. We've had a hard and difficult path even today. But the establishment of the United Nations, without question, was an extremely positive forward step in that direction. Where are we going? According to Gross, again, the history of the past 300 years tends to show that international law, increasingly separated from its roots in right reason and natural law, could not bring about the international community. So Gross is arguing that the root of international law is in this human reason and a universality to our capacity to identify the rules and the principles that we should live by. So he's saying a revival of this natural law concept thinking in the field of international law is needed. Another important distinction here is between jus civile. We talked about the law that each country created for itself. It's often called positive law, meaning these are laws not necessarily rooted in natural law reasoning, but a legislator figuring out how to create a taxation system that's fair and how to distribute goods, public goods to the people, whether it's electricity or a postal service, how to rule when crimes have been committed, how to oversee that which would be criminal law, that the state has an interest in. Someone murders another, it violates state law or even federal law, and the state intervenes. So then there is this universal law, jus gentium, the law of all peoples. This is the body of law shared by all persons by reason, based on ideals of justice and observed by all countries, rooted in this ideal of natural law. This is an ideal, it's an aspiration. It has not been brought to fruition. but it is the common base on which the laws of all civilized society were based. One finds it in the writings of Aimé de Vattel, in his book, as we see, on the people's of principles of natural law by Vattel. And Jeremy Bentham, a British scholar and academic, was one of the first to use the term international law. Martin Luther King, in his letter from Birmingham jail, wrote, "How does one determine whether a law is just or unjust? A just law is a man-made code that squares with the moral law or the law of God. An unjust law is a code that is out of harmony with the moral law. To put it in the terms of St. Thomas Aquinas, an unjust law is a human law that is not rooted in the eternal law, in the natural law." So natural law, we can say, is naturally hardwired into people. For example, that it's wrong to harm an innocent person, to steal their property. That natural law embodies this concept of justice, that someone shouldn't harm another and simply be allowed to go unpunished. It is universal in scope, and it's self-evident to individuals using right reason. It was there in the Declaration. We hold these truths to be self-evident, that all men are created equal, endowed by their Creator with inalienable rights, life, liberty, pursuit of happiness. To secure these rights, governments are instituted among men, deriving their just powers from the consent of the governed. That whatever or whenever any form of government becomes destructive of these ends, it is the right of the people to alter or abolish it and to institute new government, laying its foundation on such principles and organizing its powers in such form as to them shall seem most likely to affect their safety and happiness. So we'll return periodically to this theme of natural law. Is there a unifying principle rooted in human reason and human nature that can move us toward a community of nations and in securing human rights? That's the challenge of humanity. So with that, come to an end. There may be a short part of this recording that the sound was off. If so, please someone send me an email to let me know. Much appreciated. All right. All the very best.